West.
Well, I am from Hartford, though.
Yeah, but
Call the
But
meeting
I'm
of
not
the
one of the commissioners appointed by the
Metropolitan District Commission's
citizens.
Board of Finance
I guess.
to order. So regular meeting, Monday, March 31st. Starting a little bit late. So first on our agenda is the swearing in of a new member, a citizen member, Edwin Vargas from Hartford.
Right hand. Commissioner. Do you solemnly swear that you will faithfully uphold, according to law, your duties as a citizen member of the Metropolitan District of Hartford County, to the best of your ability, so help you?
I do.
Congratulations.
Thank you.
Welcome aboard.
All right, so are there any public comments relative to agenda items? Any public comments relative to agenda items? Hearing none, move on to item number 4, the independent consumer advocate comments and questions relative to agenda items.
What? Yeah, the agenda's online.
Yeah.
You're not operating.
Thank you. Elizabeth Tavelli, Independent Consumer Advocate. I'm responding to number 9 on the agenda for today. It says discussion regarding official duties and responsibilities of the Independent Consumer Advocate. So I would caution the conversation regarding this. This is statutorily created position. Connecticut General Statute 7334A outlines the duties and responsibilities of the Independent Consumer Advocate. It is my position that the committee does not have the authority to alter the role or to outline or define it beyond that. I'll leave it to hear the discussion today, but I do have additional thoughts depending on where the conversation goes, and some concerns just regarding, because it is an independent role and it is created by statute, exactly what authority the committee could have to sort of discuss it further than that. So I'll leave it at that for now.
Thank you. And I'll just say that when we get to the item, I think it was more an item that where commissioners could understand what it is that you think your job is. I think we haven't heard from a consumer advocate in a while, so that was. Let's see, item number 5 is approval of meeting minutes of January 27th, 2025.
So moved. Second.
Motion's been made and seconded. Are there any additions, deletions, or corrections to the minutes as presented? Hearing none, all in favor of receiving the minutes as written, signify by saying aye.
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 Thank you. Thank you. Item number 6 is consideration of potential action regarding the authorization to execute project loan and project grant agreements, project loan and project grant and principal forgiveness agreements, and interim funding obligations and project loan obligations. And I'll let our staff go on to give the details on the rest of it. We're going to hear from
Kelly Shane.
Yes, go ahead.
CEO, yes.
Thank
Go
you.
ahead, Kelly.
Kelly Shane, Chief Administrative Officer. That was a mouthful, that resolution and this agenda item, and I'm hoping to simplify and explain what you are doing and why. So that is the goal tonight, is to share the purpose of these 5 resolutions, resolutions 6A through E, share the steps of the grant and loan agreement process and the steps within these projects so you can kind of get a view of where we're at and how this comes to be and why we're asking for this administrative blanket authorization, if you will, to enter into grants and loans, loan agreements for deep funded integrated plan projects. And then also to show you some status of some of the agreements that are in the packet. We did list all the agreements in, all of the projects the funded appropriations that you've appropriated in fiscal years 23, 24, and 25 for the integrated plan, which is what we're asking for you to approve for those applicable projects to enter into at the right time for grant and loan agreements. Great. So what is the purpose of these resolutions? It's to streamline the board's and first, obviously, the Finance Committee's authorization to execute the project grant and loan agreements for the integrated plan projects that DEEP has identified as being available for 2% loans and a percentage grant. All of the North Hartford projects, and several other larger projects that are part of the integrated plan that has been approved by DEEP. So what is in a lot of that legal information that's in the resolution that was developed by our bond counsel, it's authorizing an interim funding obligation. So what this comes down to really is allowing us reimbursement of the eligible project funding during project construction. So DEEP tells us for every project that goes to them, they give us the eligibility. They tell us for that construction project or that project in general, what's eligible for grant funding and what percentage, what's eligible for 2% loan, and what may be our own share that we're responsible to pay for. So the interim funding obligation within a grant and loan agreement is the ability for us to draw funds during construction project, because once a construction project starts, every month we are paying out of pocket for the services that are being provided by that construction contract. Construction contractor. As they progress, we pay monthly. So this is allowing us, as part of the grant and loan agreement and the application process, which I'm going to go into specifically what that process is. It allows us to draw from DEEP for the reimbursement for those costs. And then authorizing the loan obligation, that's the 2% loan. So after the project is complete, that's our debt service that we pay. We pay back the 2% loan once the project is complete. So this grant and loan agreement allows us then to pay back the interim funding that we drew as reimbursement for the portion of the grant. The portion of the loan. We don't pay back the grant. We are able to keep that grant money. Does that make sense? Yeah. All right. So here is the process that I wanted to share with you tonight. Put it into blocks so you could see. So in December, every year from 23, 24, and 25, the board approved our CIP budget annually. You approved the appropriations for each year's integrated plan budget. So those were all the projects, and they were listed in the agenda, all the projects for the integrated plan. What we are proposing tonight is that the board approve authorization in the future to execute the project loan and grant agreements through a resolution for the eligible IP projects. And we would like to do that when you approve the budget in December. You also approve a resolution to authorize us to, when the time is right, enter into those grant and loan agreements. Why is that important? I'm going to show you as we go through these steps. So let's take a step back and look at a construction project and the process we go through with DEEP. Engineering works with DEEP on the design, the construction, the plans, the specs, the bid documents of any project that's been identified by DEEP as being eligible for grants, loans, and they also tell us how much we're responsible to pay for ourselves, the MDC share. So they do that as we're developing those plan specs and bid documents. They're also identifying and approving the eligibility. We design and bid the projects out, and DEEP approves that contract award at the end of the day. So they approve before we go out to a bid. They also approve. They're very involved in the design and bidding of a construction project. Once the district awards the construction project, like I mentioned before, we have to start paying every month for the progress of that construction project. At that time, when we award that contract, that's when we can submit, and this is in our nirvana world, okay? Because I'm going to mention some nuances we have. In our world, as soon as we issue the construction contract, we start paying monthly invoices as they continue to perform. We submit the funding application to DEEP. That's the application for the IFO and the PLO, the interim funding obligation and the project loan obligation, which is our request for the grant and loan agreement. In the best world, we would get that right back from DEEP. We would work with bond counsel and with the state, and we would get that agreement. We, in the past, have come to you. First, DEEP approves, drafts the grant and loan agreement, and then we have historically come to you for every project, to the Finance Committee first, gotten approval to go forward with executing that grant and loan agreement, and then have gone to the board after it's been approved by this committee, gone to the board. Sometimes that can lag depending on when when the Finance Committee meeting is and the board meeting is. That can lag by a month, might be even longer. And then once we get approval by the board, we then go and execute that agreement. Not until then can we begin submitting for those interim funds, can we begin submitting for reimbursement. Yes,
Kelly.
sir. Yep.
Excuse me, let me interrupt for just a second. So this is a really important part of this presentation. We asked that because we had such a big chunk of these going through here, it'd be a good time to explain step by step what happens. But until we get those agreements and until they start making the reimbursements, Scott has told us a bunch of times that we have to write checks for these projects. So, she can explain, or you can explain how that happens. We just comes right out of our regular checkbook. So it's really important we get these things funded, because if we have a lot of construction projects and a lot of payments, we're burning down our balance in our checkbook. But that's, you go ahead.
Yeah, no, and that's correct. I mean, what Kelly's asking for is, instead of us coming to you, we have bureaucracy in front of us, right? DEEP says you have to do this, and okay, we have to do it. But as we mentioned in our early meetings, and I mentioned this before, MDC spends about $35 million a month on stuff. And that includes all this stuff we're talking about. We have one we have one checkbook at the MDC, a general fund. It's really the sewer fund, and all the money goes in there, and we're using ledgers to keep track of where we're spending money. And if we, all of the work that we started in North Hartford, all the work in North Hartford, we haven't got one penny back yet. So, the challenge is, we're asking the board to approve these now in a lump sum, with all of these in front of you. But also what Kelly's suggesting is, moving forward next year, next budget, as you approve the CIP and or the integrated planning projects as part of the budget, you also approve a resolution to give us the authority to enter into these loan agreements, because that's the only way we can get reimbursed. The board's already approved the projects. The projects have already been, vetted through finance and through the full board. We're simply asking for authorization to enter into the agreements, the loan agreements, interim and long-term. But that's the issue.
All right, thank you. Listen, thank you, Scott. And go ahead, Kelly, you can go ahead and finish. Just want to make sure there is some urgency to do these things. I just got to just explain what it is. So,
And just as an example, because Commissioner, you had asked for some statuses on some of these projects.
Yes.
So I identified, like for item 6A, the 23 CIP budget, There are some projects, like this first one, resolution number 27, the large diameter sewers. DEEP has approved that project. It's in construction. We've submitted the application, and but we're still waiting for that to be approved so that we can start getting reimbursed. There are others that are in design. So I'll move on. These are just examples. We have some that are North Hartford work, you can see. Some's in construction, some North Hartford work. The funding application has been submitted, but again, not yet approved, which is why we have not been able to submit for reimbursement. This would allow us the opportunity, as soon as they are approved, for us to move forward with those agreements. And those agreements are signed by the chairman and, at present, myself as acting treasurer, and in future, the CFO. So yes.
Go ahead, Bill.
How much of that revolving fund is federal money?
How much of the revolving fund is federal money?
Is it all state money?
If I may.
Yes.
Yes, if I may. I've asked this question probably 1,000 times and I've never got a straight answer, but I've been told if it's 1%, it's a penny, you have to comply with all the federal regulations, so that's why we do. But I've been told that from deep leadership that it's less than 15%.
They hit for $508 million so far. So I'm just wondering what the impact that's going through their mind, but they're still positive on it?
Yeah.
Well, good for them. Good for them, right? Today. I hope they're as optimistic as.
So the key considerations here is really that we'd like to streamline this administratively, and that would expedite we're already up against it with DEEP. Sometimes they withhold because they might be looking for funds. They withhold the applications on us. So what we're looking for is the opportunity. You're just granting us the authority to exercise and execute these agreements at the right time when we're able to. You've already approved the authorization and the spending that we can do. We're looking for the authorization to jump into these grant and loan agreements at the right time. They're always done by bond counsel and managed through bond counsel with the state. And that's really my presentation.
Does anybody, have any questions? I'm sorry, go ahead.
That's right.
I didn't see
So, did I misunderstand what you just said a little bit about DEEP unilaterally determining or deciding to put a roadblock up?
I wouldn't call it a roadblock. I would call it that we can submit those applications when we start construction because they've approved us to be able to move forward. However, we are at their mercy as far as when they approve them and send them back to us. And also when they say, okay, we're going to draft the grant and loan agreement, they draft it. So until they draft it, we're unable to move forward with executing it.
So, follow up
Go ahead.
again. So, who actually advocates for us?
We all do. Bi-weekly meetings, Susan, Chris, myself, Viviana, who is here, who does all of these applications. Viviana, stand up, please. She works tirelessly with DEEP and the DEEP accounting staff to put forth these applications as soon as humanly possible. But we all meet with DEEP management as well to work through all of these requests, and they know they get copies of the invoices or the payment applications that we process so they know what we're paying.
So the only thing I would follow up with that is, can't we supercharge this process? I mean,
So-
if in fact this young lady is doing the Lord's work over there, she needs help.
If I may. Yeah, so, to be fair to Deep, I mean, obviously bureaucracy is bureaucracy, right? The one thing I would say is that especially with all the North Hartford projects, you remember we changed the way we do things in North Hartford, and we changed it by the consent order through the integrated plan. We changed it with Deep and the funding agreements. And so we had to go through a huge learning curve over the last, since July of 2023, when we started digging in North Hartford. And a lot of the work on the private property side was never, ever, ever, ever allowed to be covered under the Clean Water Project. Now it is. So we had to go through a very exhaustive working sessions with Deep staff and our staff to agree on how they were going to reimburse us for that private property work. But it is what it is. But they are, it is a very beneficial program for us at the MDC, and we're able to capitalize on it, unlike most of the towns. But what this would help us do is this resolution or these approvals would be to eliminate our bureaucracy. And our bureaucracy is simply waiting for the Deep to finish and then having to come back to finance and the full board to get the final approval. We're just asking to approve them up front. And then we can just, as soon as Deep approves them, we can start reimbursing or requesting reimbursement. So it'll save us, 2 to 3 months per project. And as I said, $35 million a month adds up, right?
We're not, and just to be sure, and, I know you say the word bureaucracy like it's a windmill that you're gonna be out there, charging on, jousting on, Scott, but, it's not, we're not skipping anything.
No.
No.
In our process, we're just doing it now instead of waiting for them,
Correct.
but everything else that was supposed to happen before, that was the whole point of this presentation, was everything else that was supposed to happen before, design, bidding, construction, all that, Deep approval of the project, that's all still gonna happen when it was supposed to happen. We're not changing that, we're just moving it. And to be, I guess somewhat, to sort of explain what Deep is, what they're doing is, there are times, I'm sure, where they just don't have the money in place to give us. And so there's, they're made just for the same reasons that we don't have it from them. There's somebody that's supposed to give it to them, and they don't have it from them yet. And there's times when, maybe that doesn't get explained, but it just looks like they're sitting on an application. And it may not be, intentionally trying to slow us down, but I would say that this is a really good proposal that the staff put together. I'm glad they did, and I did ask for them to make a special presentation so that everybody here could understand what we were trying to do with it, and that we weren't trying to, just hurry up and skip over anything. We're trying to, give ourselves the best opportunity to get these things started. So, some of these construction projects are seasonal. If we don't start them at the right time, we lose money immediately, because of the additional costs. So Kelly, if you're through with the presentation, we don't have the clerk here tonight. I'm going to rely on you, Chris, to the resolution. I mean, can you go ahead and do it?
Yeah, you can do it all in one vote, move items 6A through E.
Right.
It's fine.
Yeah, I'd appreciate if you can do it. Can you read the resolution? I just want to make sure you
Oh, sure.
can get it right.
I think is that the longest resolution in the,
Oh, no, you don't have to read the whole thing. I mean, just explain the resolution.
Yeah, what we're-
I'm sorry, I didn't mean that.
No, I'm just teasing. So what it's been suggested that as to item 6 is, as you can see, it's divided up into 5 different, I'll call them subcategories or sub-resolutions. And each of the resolutions are set forth in your packet. If you, without objection, of course, but if there is no objection and you want to move that item in its entirety, By doing so, you would be, and you, if you, should you vote to approve the resolution, you would approving all of them, 6A through E. And all of them relate to the same issues that Kelly brought up generally in terms of what we're trying to accomplish and how we're trying to expedite at least our internal bureaucracy so that things can get done a little quicker than.
I will, without objection to combining them, I'll, call for a vote on the resolution, unless there's an objection. If there isn't,
So moved.
Second.
motion's been made and seconded. All in favor signify by saying aye.
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 Aye. Any opposed? Any abstentions? Hearing none, the motion carries. So thank you very much. Thank you, Kelly and Scott.
Yeah, thank you, Kelly.
There's a lot of work, and I appreciate doing that for us. Yeah. Item number 7 is the review of the finalized accounting for the Bob Barron payment projection. This is the exhibit that was sent out together with the agreement. And at the time, it was a projection, and it's now an actual amount. So can you confirm for us, Chris, I guess you can do this, right? Confirm for us the totals on the various things. You had a payroll and some other payments and benefit payments. Just confirm for us what those came out to be.
Sure. Let me just pull up the agreement on my computer because I've got I don't think it was included in the agenda. I'm not sure. But let me pull it up. And while I'm doing this, we did.
He's looking, just to be sure this is all right in public session.
It is, and that's.
Yeah, we
part of what I
talked
was gonna-
about that.
that's part of what
I'm sorry, Mr. Chairman, we did speak about that before. I'm sorry, I should have explained that.
So this is as to this, but this is an exhibit to the settlement, to the agreement reached between us and Bob Barron when he retired. I had sent out an email some time ago, which included not only this agreement as in the exhibit as an attachment, but also contained some, what I consider to be legal advice or legal comments that were protected by a privilege that I'm not able to waive, that you would only be able to waive. So I sent it as an attorney-client privilege document. Chairman Slemmy and I had a discussion earlier today about that. I explained why it was attorney-client privilege, but I also explained that as to the document itself, the attachment, that is a public document and can be publicly disclosed, and in fact, it has been to you, and in that regard, as a public document. So, that being said, attached to that is the payout. There was some discussion after the payout was proposed between us and Mr. Barron. There was some, I won't say there was a give and take, but he had some questions about it, but they've worked out through Jamie's office and Kelly's office, worked out the numbers. The numbers that were set forth in that agreement are in fact the numbers that were in fact paid out.
Well, I think that's, and if that's the case, if there's no variation on the total amount that it added up to, then I think that we've answered the question. And
Okay.
there's no variation on
Right.
what we said we were gonna do. That is what we did, in fact.
And I've confirmed that, Mr. Chairman, as I
Okay.
alluded to earlier, confirmed that with Jamie Harlow, HR Director, and an email she sent me says what we set forth in the agreement is exactly what we paid out, so.
I would suggest that if anybody, and if you should all have this, Chris sent it out on December 2nd, I think is the date that he sent it out on, but if you, it's an email with 2 attachments. If you have any questions about the actual amounts or how it was calculated or anything, then you could certainly call Chris or send him an email or ask him about it. And unless there's something specific that somebody wants to ask now, that we can go ahead. Commissioner Adel?
The only question I had was, I know he left in November?
October.
October, thank you.
It's the end of October. He left October 25th or something like that.
And then left November 10th,
Okay, November
or
10th.
the week of November 10th. I don't know which day exactly it was.
Now, what impacted,
Oh, okay.
what impacted paying him through, where did we go through till, no, what was
Till
it,
the 1st of
July-
February.
January 31st, or, okay. What impact that's, by bringing him into 2025, did that impact his payouts going forward? Because, I mean, he could live 30 years, so that impacts.
His
Perhaps.
pension was relatively, if you're asking about the pension, effect on pension is relatively de minimis because he wasn't here. You know, your pension is based upon number of years work times a percentage, 2% is the NBC pension. Adding another month, and by the way, it wasn't just adding a month just to increase a pension, because it was, like I said, de minimis based upon the number of years he was here. But he did make himself available if there were questions and in fact, I had to call him on a couple of occasions with questions, not about this, but about other things with finance. So he was very helpful, made himself accessible to us. So there was a whole myriad of opportunities that we could have had over that time to access him and his expertise and his knowledge based upon the time that he was here. But in terms of the effect on the pension, relatively insignificant based upon, the overall payout, so.
Yeah, I'd say one noticeable thing on it, on the payroll part of it is it's the same thing that everybody that works here got, which is in January 1st.
Yeah.
So he was awarded the raise that everybody else
Right,
got
yeah.
on January 1st, so. And that did, over time, that does affect it, like you said, it's kind of a diminished amount, but, certainly it did, but. Alan?
He gets 7%. He was here 3.5 years, he's at 7%.
Yeah.
Yeah, Commissioner Hoffman, just to clarify, if I can, yes, we received this memo, et cetera, from Attorney Stone. But should we not, as part of the public record, itemize that situation in its finality during this meeting, or not? I'm not saying we should or shouldn't. I'm asking.
If I might, through you, Mr. Chairman, it's
Sure.
not necessary for it to be itemized or finalized or anything of that nature. Remember, he had a right to retire. He has retired. He's very happy in his retirement. This is not out of the ordinary for what we do for that level of employee when they retire. In fact, I will tell you that I've seen agreements upon separation that exceed the amount in the carryover that is represented here. So this is not out of the ordinary. It really represents, at least up to a point, and remember, he made himself available for the 2 months in 2025, but everything, even if you look at below the line, his HSA contributions, your accruals, vacation accruals, that's standard. There was nothing in additional benefit in those areas, those payouts, that he didn't otherwise have vested and had coming to him whenever he retired, and whatever those numbers were at the time that he retired. So that's where we are.
I think, I just let me say, and you can, and Alan, you can do it. We weren't going to discuss the nature of the agreement versus other agreements. And this was just about the payout. So, and with the determination that there's no variance from what was on this sheet to what was actually paid to him, you can add up the totals, and it's a significant amount, but, you can add them up and, but go ahead, Alan, I'm
Yeah,
sorry.
no, I'm not necessarily interested in the specific amount, only for the public record if necessary. But I do know and was aware that there was some suggestion of a discrepancy in the numbers that were batted back and forth casually. And so I'm saying, if there was a problem along the way, then we should unscramble it right now, if that's appropriate. If it's not, I understand, and I'm not gonna advocate either way.
It's not necessary because these numbers represent what we calculate to be.
That's it. Very good, thank you.
Mr. Chairman,
Yes,
I
Commissioner
may.
Russo.
just looking, Mike, I'm not near a mic, really, so. Just looking at this agreement on page 8, there's an error as to the date underneath the signature of the Director of Human Resources. It indicates it was signed November 21st, 2025.
Yeah, that's an error for sure, yeah.
Yeah, so that
Uh,
needs to be amended or corrected.
Yeah, and as I said, I think Chris sent this
I
out
don't know
on
how
December
that-
2nd,
yeah.
so.
If you look at the acknowledgement, it says, uses the 24th, so there is, I hear you, I don't know how it got to be, I don't know how that, well, the agreement's expired. Right? Well, the agreement's still in effect because there's certain, conditions on there, but.
Well, as I said,
If you like, and honestly, I'm sorry for interrupting, Mr. Chairman.
I was just gonna say, as I said, I mean, there's no variation from what, was here to what we did. I expect that it's an auditable thing, so that if there's any question about whether or not we need it it's there, and so, like I said, if there's any other question related to the amounts and, what they represent, I think you could certainly ask Chris, and anytime, if there's anything else. Okay, if there's nothing else, we can move on to the next item. This wasn't really set up for a vote or anything, so. Okay, so item number 8 is staff update on resolution of outstanding change orders and work change directives submitted by Kenny Obayashi, joint venture, related to the completion of the South Hartford Storage and Conveyance Tunnel. I asked that we could, because it looked like we were gonna have a final resolution, all the numbers and everything, and we almost do. But Chris has explained that there's a couple of issues that are outstanding that we have to kind of let them sort of take their natural course and finish up before we really get involved in discussing the details of it. I would say that the reason that we've asked to have this is, and I asked that what we come up with in the end for we'll call it our story about the change order, is that we just say it one time, and that Chris can do it, or he can have somebody else do it, but that in that way that all the towns will understand it the same way, all the commissioners here and everything, and legislature, everybody will understand it the same way. It's probably one of the biggest construction change orders ever written in Connecticut. I think maybe the New London Pier has maybe a little bit bigger one, but and I think that we've been working on it for an awful long time. It's years, really. It's not just months. So I wanted to give it a chance to get finalized, so that there's no questions left. If you have a question, we have the answer for it. So Chris, why don't you just explain the status of where we're at now and when we think we're going to have the finalized agreement?
You bet. Well, first of all, the good news is that a lot of things have happened since January. Well, it was tentatively settled in mediation on December 17th, 2004. And then I will tell you, you heard a presentation from Kelly about staff and working through DEEP. I don't want to name any names because I'll forget somebody, but everybody in that department, finance and in engineering, did a terrific job in getting the change orders finalized, the change work director orders finalized, so that everything worked out to the penny as to what was owed to the claimant, what was owed in terms of retainage to the claimant. And they were able to turn that around with representatives from KOJV, but I will tell you, as I see it, our staff did most of the work, but turn that around so that we were able to have the resolution that you approved on January 13th. The work began then. We submitted the final change orders and work change directives to DEEP, because under our contract, under the contract, aside from DEEP participation in funding, in order to even be considered for that participation, DEEP has to approve any change order or change work directive in excess of $100,000. So, and this clearly was. So that was submitted to DEEP. And you talk about sometimes DEEP takes some time. In this particular case, they reviewed change orders and work change directives that were not signed by the contractor yet, because we asked them to move it apace and get to it before, when it was in draft form. The final signed change orders and work change directives reflect what was in those drafts, unsigned drafts that the contractor and our staff worked on. So that's good, and DEEP agreed to do that for us. Susan, what was the date that we got the approval? It was 2 weeks ago, and you knew I was going to ask you, right?
Thanks, Chris.
But we were engaged in, now we're talking about the process agreement for how these change orders are processed and paid. They wanted a date certain as to when the settlement money was going to be paid. We couldn't give them a date certain because we're not going to make a payment to them so long as it's still pending at DEEP, because that's going to eliminate our ability to seek reimbursement. So there was a significant risk to the MDC if we were to have paid and then before DEEP acted. So we had a court hearing, judges involved, et cetera. The day after the court hearing, DEEP sent us a letter, and it's just by coincidence, a letter approving all but $28,000 of the $51 million in change orders and work change directives. So that was good news. Obviously, it was welcome news by the contractor. We have now finalized. Now, once that happened, all those change orders all of a sudden got signed. Work change directives got signed, formally submitted to DEEP. So that's all good. And now we're waiting on a couple things before I can actually put together that document or that statement that you like, and I think is a great idea, by the way, to get that one message out there. We're waiting on DEEP's determination on contribution under the, and correct me if I'm wrong, Susan, under the loan agreements. There's they participate in, they approved this project some time ago. I think it's a 45% reimbursement on the change orders as a grant, and then the rest is that also covered by the 2% loan. So of the $51 million, we're hoping that DEEP contributes the full 45%, which would be just under $23 million. So that's all good news. And we didn't want to put that into jeopardy by doing something fancy, outside the terms of the contract. So that being said, the other thing we're waiting for is the final bills are coming in from experts and lawyers. And that's all covered within the project budget, not out of our operational budget. But I think in fairness to everybody, especially the finance board and the full board, you should know what those numbers are in total, rather than, over. I don't want to have to give them to you, then correct them or add to them. So you'll have those relatively soon. I've told the lawyers that I want their final March billing within 5 days of March 31st. That I don't expect the need for any other lawyers' fees, and that they're not to spend any more time on this case unless I authorize it. But I don't see a need to do it. So we're looking at an April timeframe, end of April, where I can get that together for. And if you want to have a meeting before the board meeting, great. If you want to just do it at the board meeting, that's fine too. But that'll be distributed before the end of April.
I think we can agree that we don't need to hear it before the board meeting. We will all just hear it at the board meeting. I know we have citizen members that but they can certainly avail themselves of watching it online. I don't want you to have to do it twice. I think one time would be good. I do want to add a couple of things, or ask you to explain maybe just a couple of quick things that One is on the federal government, which is a major contributor to this project, does not pay for change orders, from my understanding. They're not contributing to paying for this change order, is that correct?
Well,
Or,
the Clean Water Funds,
but I mean,
is
it's
the
deep,
source.
it's not directly from them, it's gonna be,
Nothing's directly from them. The federal government, as Scott said earlier, funds about
15%.
15% of the Clean
Yeah.
Water Fund, but it's Deep makes the call on.
right, so I thought I had that right, but you explained it a little bit better, so we're not, so, all of this work is being done through DEEP, and that's why we have to wait to get this thing done. The other thing is, Chris, you mentioned that there are additional costs that are outside the actual change order for experts and stuff that we had, but that those costs can still be paid for by the project. My understanding, Scott, is that there's still, we didn't blow out the project contingency with this 51 million. There's still additional funds left in the contingency, or there is, or there isn't?
Yeah, so just remember how we funded the first two referendums. The board approved 800 million and twice, 2006, 2012. So during the first phases of the Clean Water Project, which included this project, we had a contingency of $1.6 billion. The board didn't approve project by project. We had $1.6 billion to spend. We developed our own internal, we refer to it as the Bible, and every project has its own component of the 1.6, and then we apply contingency to that project. And that's more of a, it's not a mandate from anyone, it's just a natural way of keeping track of your budget. And then in addition to that, we received another $200 million due to the legislation change in 2013 for the grant portion of the 1.6 billion. So we allocated $70 million under the project for the tunnel. And of that 70 million, obviously, for this change order, we spent 51, and we're going to get 42% grant on that, minus the 28,000 on that component. But out of all of the money left over of the 1.8 billion, and every time we get grant money, you add to the 1.8. So the 1.8 grows every time you get grant money. We have about $100 million left over. But we also have another very expensive project that hasn't even started yet, which is, it's still in, we haven't started, it's in study phase. And that's roughly an $80 million project. So we've got about we only spent 51 of the $70 million in the contingency. This project, this change order, this project was roughly $300 million. And without this, the water change orders for reaches 2 and 3 and partly in 1, we would have, without that, we would have only been at about 1.9% of change dollars in change orders for the contract value. You add this in, and we're only at 19%. And as we provided, there's a lot of projects that we provided deep that had 50%, 100% change orders. You got to remember, building a tunnel under the ground, 250 feet, with crevices the size you could drive a car into. We always said water is our biggest enemy and it's the biggest unknown. And the contract amount for the contractor to stop, drop, and roll because of water or because of any condition that's not his doing is $6,600 an hour. So you can see how a project that lasted almost 4 years, how quickly water can affect a project of this magnitude. No one got hurt, no one got died. A lot of projects across the country, the tunnel machine actually was swallowed by water and had to be abandoned. Seattle projects and other projects. We didn't have any of that. And so it's a testament to our staff, to our consultants, to the contractor that we finished the project. But we did have a change order for water conditions, unforeseen conditions, which totals about 19%, a little more than 19% of the contract value.
I wanted to make sure too that, and Chris, I'll be happy to work with you on this, that the narrative that we put together explains that for a tunnel project or anything that's underground, and what in the business we would call, unforeseen underground conditions, things that you can't see no matter how hard you look, that we did pretty well, that a total of 19 to 20% in change orders for a project like that is, not an exceptional amount. It's more or less a standard amount and something you might expect from the beginning, which is why we had a $70 million contingency in the first place. If that happened, if we were building a storage warehouse somewhere, we'd have a huge problem with that. So anyway, we'll make sure that gets into the narrative, Scott, and that gets explained that way. But I want to thank everybody for their patience on this. We want to get it right because it's going to hit the public. It's a big number, and we want to make sure that everybody understands that it's still a successful project. So. Where were we? Item 8, no, item 9. So discussion on official duties and responsibilities of the independent consumer advocate. I didn't write that, so I'm not sure. I'm not sure exactly what it meant, but I think I know what it means to me. But go ahead, Commissioner.
Thank you, Mr. Chairman. To avoid any lengthy, if any, discussion at all, maybe we could just direct District Council to send out Public Act 17-1 and any relevant documentation that guides our ICA so that we have a better understanding of what her duties and responsibilities are as it relates to MDC.
I think that'd be good. I think with the last the Consumer Council we've had two, with the last one and then the first one we had. I think that the main issue was that they were going to turn over quarterly reports, which they did. That was the one thing that turned out to be a responsibility, but I'm sure if we send out the statute, that everybody will get a good idea exactly. And then, of course, Elizabeth, you can explain to us what you think. But you think they'll be happy to hear from you when we get that done. So can you take care of that?
Yes, if I might, Mr. Chairman, through you.
So close.
No, it will be quick. It'll be quick. I'm going to send you two things, all right? I'm going to send you the original bill, Special Act, I think it was 1701. I'll send you the original piece of legislation. There was a follow-up in 2024. You have a copy of that was on open text, but I'll send it to you separately, so you'll get two things. One they don't change the duties of the consumer advocate, but I want to get you the whole picture. It adds a little bit more money on the second part, if you recall, from 2024. But you'll get the whole thing, okay? That's it.
Any other questions? Alan, go
Just a
ahead.
comment, just to the Consumer Council advocate. I think I would offer this to anyone who is filling that role, and that is to go back to the first consumer advocate that we had, and just a quick review of what he discovered and what he ended up defining the role to be was quite good. I know that many of us did not always agree with Dave, but he did provide structure and he did provide direction. And so I think that any consumer advocate wants to see what it's like, go to see Dave, because I thought he was very good, not always in agreement, but he was very good.
Anyone else?
Take it or leave it.
Okay. Hearing none. Item number 10 is opportunity for general public comments. Are there any general public comments? Anybody online? I don't know if there's anybody on. If there's any public online? No? Okay. Okay, item number 11, commissioner request for consideration of future agenda items. Mr. Adel.
I'd like at some point to revisit the tunnel project for the connection to the south end, Hartford, Weathersfield Cove, and see where staff feels we'll be able to get that back into the queue again.
Yeah, do you Did you get to understand that?
I do,
I mean,
yes.
John's not here to write this down, but I mean,
It's, just to be, just to be clear, it's
Sure.
not a budgetary issue, right? We will bring that project when it's ready to be brought to Board of Finance and the full board to get approval, but we're in design stages and study stages right now on that, and that project was deferred, as you remember, it was deferred as part of the changes that we made for the North Hartford projects. The only way we could afford to do what we're doing in North Hartford was defer $300 million worth of work, and that project was one of them. But we're required to have a design by 2027 for that project.
anyone else? Any other commissioner requests for future items? Okay, hearing none, so Chair will entertain a motion to adjourn. Without objection,